Chicago, February 2023. Snow lay thin, like the last breath of the night. The wind tore across the frozen stone steps of the Cook County Courthouse. Monday morning, seemingly just another Monday. Attorney Delaney Cross, 33, arrived at exactly 8:59 a.m. She entered courtroom 4, her posture straight, her gray blazer tailored to fit, her worn brown leather briefcase bearing the marks of time. In her mind, this was just another mid-level commercial dispute. No press, no audience, nothing memorable. Until she met Judge Gerald Whitmore's gaze. Not the usual glance from the bench, but a cold, piercing stare, fixed on the Star of David earring, peeking from behind her hair. The air in the courtroom shifted, as if something that wasn't meant to be had just appeared. Whitmore struck his gavel. His voice was steel. "Ms. Cross, religious symbols are not permitted here. Remove it or face sanction." Delaney did not flinch, did not blink. "Your Honor," she said evenly, "the wedding ring on your finger is also a personal symbol. I wonder, what makes this different?" A murmur rippled through the gallery. The clerk looked up, stole a quick glance at Whitmore, then immediately lowered her head. Whitmore hesitated for a second. Then his voice turned to ice. "500 fine. Put it on record." Delaney did not remove the earring, did not react. She simply set down her briefcase, clasped her hands before her, and met his stare. "I object, and I request my formal rebuttal be entered into the case record." Whitmore clenched his jaw. "Are you turning this contract dispute into a religious debate?" Delaney's gaze did not waver. "I am simply reminding you, Your Honor, that personal freedoms, under the Constitution, do not end at the courthouse door." All eyes in the room were on her now. The air felt frozen. This morning's case had been nothing more than a contract dispute. But in that moment, everyone realized something greater than the law had just begun. The air in courtroom 4 was thick as winter fog. Delaney Cross remained upright, her gaze locked on the judge. Judge Gerald Whitmore folded his arms. His voice was dry. "This is a court of law, not a personal platform. If I allow one form of expression, I must allow them all." Delaney raised an eyebrow. "You mean like your wedding ring? Like the union pins other attorneys are wearing? Or the time you permitted a lawyer to wear a pink ribbon for breast cancer awareness in a criminal trial?" A soft cough. A few glances exchanged in the gallery. Whitmore's eyes flicked toward them. A slight flush crept up his face. Delaney leaned forward, her voice quieter but sharp as a blade. "Your Honor, if the law is the law, it must be applied consistently. Otherwise, it is merely personal will." Silence stretched between them. Then Whitmore turned to the clerk. "Note, fine to be placed under review." Delaney smiled, subtle but deliberate. "I see that as a step forward." But she knew. This was far from over. It was only the prelude, because the silence that followed in Whitmore's eyes was not acceptance. It was calculation. The battle had simply shifted form. Delaney could feel the weight of the stares, from the clerk, from familiar colleagues in the room. No one had expected a simple commercial case to become a direct challenge to the boundaries of personal rights, right in the heart of the legal system. After the hearing, her client, a middle-aged Asian man, rose and gave her a slight nod. "I hired you to protect my contract. I did not expect to witness you protect something far greater." Delaney only nodded. "Justice does not come in sizes, Mr. Hahn." And she stepped out of the courtroom, where the real storm was still waiting. The next day, 8:13 a.m., Delaney Cross had just set her coffee down when her internal inbox lit up. A simple subject line. "Notice from the Illinois Attorney Ethics Committee." She opened it. A 3-page document, formal, cold, accusing her of disrupting courtroom proceedings, challenging judicial authority, and violating professional conduct. Filed by Judge Gerald Whitmore. Delaney wasn't surprised. She only smiled, just slightly. The kind of smile that wasn't amused, but entirely lucid. She knew this move. Old, but still effective. Because when they lose in the light, they attack in the dark. Her assistant Nina stepped in, phone in hand. Fox Law Weekly just reached out. They're asking if you have any comment on the religious controversy in court. Delaney shook her head. Not yet. We don't play defense. She sat down and reread the complaint. It was crafted carefully, framing her as if she had caused disorder, as if standing up for individual rights was non-compliance. He doesn't want to handle this in the courtroom, she said slowly. He wants to handle me through the committee, quietly, off the record, no cameras. Nina's expression turned serious. How do you plan to respond? Delaney looked up, gaze steady. Publicly. She unlocked her phone, scrolled through her contacts. A familiar name appeared. Maya Coleman, investigative reporter, CBS Chicago. She tapped call. Maya, I have a story, not about a lawsuit, about a judge using the system to punish a lawyer for challenging him over a tiny earring. A brief silence, then a simple response. I'll be at your office in 30 minutes. The game had changed. Whitmore chose the shadows. Delaney turned on the lights. That afternoon, Maya Coleman sat across from Delaney in her brightly lit office. The veteran journalist, black turtleneck, eyes sharp as a camera lens, needed no long introductions. You're confirming Judge Whitmore personally filed a complaint with the Ethics Committee just because you refused to remove the Star of David earring? Delaney nodded. Not because I disrupted court, because I refused to be silent. Maya took notes. Her face remained neutral, but her eyes, curious, indignant, said everything. 3 hours later, CBS Chicago aired its first report. A simple yet powerful headline, Attorney Threatened by Judge Over Symbol of Faith. A new legal battle over religious freedom in court. The internet erupted. Hashtags like Nader Stand with Delaney and Judicial Overreach spread like wildfire. On Twitter, a law professor from Northwestern wrote, if a judge can fine an attorney over a small symbol, what happens to clients who have no power to defend themselves? At the same time, the Ethics Committee received over 800 emails from citizens opposing the investigation. The next morning, the Illinois Law Journal published an editorial. Whitmore isn't protecting courtroom neutrality. He's testing the limits of power and of silence. In the office, Nina set down her tablet, scrolling through the headlines. You're a big name now, Delaney smirked. I don't want to be a symbol. I just want to remind people that the Constitution doesn't take a break at the courtroom door. But she knew this was no longer just her fight. When Maya called back, her voice had lost its usual cool edge. Delaney, I just got confirmation. Whitmore is lobbying behind the scenes. He's not acting alone. Delaney looked out the window. The snow was beginning to melt. Then we shine an even brighter light. Day 3 after the hearing. Delaney stepped into the office, and for the first time she saw her colleagues waiting, not to argue, but to watch. A few silent nods, a few unreadable gazes, whether admiration or apprehension, she couldn't tell. She had become the center of a storm she never set out to create, but now they were all looking to her, to see if they should step forward too. On her desk sat a thin envelope from the Ethics Committee. In response to public and media interest, a preliminary hearing will be held within 10 days. No dismissal, no retraction, just a shift in strategy from backroom pressure to open scrutiny. Delaney understood. This was Whitmore's play. If he couldn't silence her through procedure, he would force her to endure the weight of public exposure. Nina entered, holding a copy of the counterclaim Delaney had filed the night before, accusing Whitmore of judicial misconduct for using his position to retaliate against an attorney. First counterstrike sent. 2 more responses pending from legal organizations. They're in internal meetings. Delaney sat down, opened her laptop, and skimmed the latest legal news. One headline caught her eye. Civil Liberties Bar Association considers intervention in Cross versus Whitmore. Good, she murmured. If this is a crack in the system, light needs to come from every direction. That afternoon, she received an email from the Massachusetts Freedom Lawyers Organization, offering to collaborate on a proposal to define judicial limits on restricting personal expression. She sat in silence for a moment. She had only intended to challenge an unjust penalty. Now she was helping reshape the boundaries of the entire profession. Nina approached. Are you ready? This isn't just a personal case anymore. Delaney nodded. It never was. People just refused to see it. The hearing, Illinois Attorney Ethics Committee. Hearing room, 14th floor, Central Administrative Building. It didn't look like a courtroom. No gavel, no audience. But the air was colder, because here, power hid behind procedure. Delaney Cross sat at a long table facing 5 committee members, 3 retired judges, 2 senior attorneys. Across from her, Whitmore was absent. He had sent legal representation instead. Keeping his hands clean, she thought. The lead panelist spoke first. Ms. Cross, do you acknowledge that you refused the order to remove religious jewelry in court? Delaney nodded. I do, and I maintain that under the First Amendment, it was not unlawful, so long as it did not disrupt proceedings. One of the committee members tilted his head. Then in your view, do limits on expression exist in the courtroom? Delaney didn't hesitate. Yes, but they must be based on universal principles, not the personal preferences of a man wearing judicial robes. Silence, not tense, attentive. After a moment, Whitmore's representative began reading a lengthy statement, arguing that Delaney's actions posed a risk to the dignity of the court. But then he made a mistake. A courtroom must uphold its image, and attorneys must understand when not to obscure that image. Delaney met the panel's gaze. If a personal symbol of faith is considered a threat to the image of justice, then perhaps we should re-examine what exactly that image is built upon. After the hearing, no one spoke. But as Delaney stepped into the hallway, a young female attorney stood waiting. She spoke softly. I wear a small peace sign necklace. I won't take it off anymore. Delaney smiled. Not a victory, but movement. 3 hours after the hearing, on national television, WBLN aired a special report with the headline, Delaney Cross, Defender of Freedom or Challenger of the System. The segment split the studio in 2. On one side, a conservative commentator criticized Delaney for undermining the court's authority. On the other, a civil rights attorney argued that her actions were a sobering reminder of power's boundaries. Delaney sat in her office watching the clip. Not angry, not pleased. She had expected this. When a woman speaks up, they call her too sharp. When she speaks about faith, they say she's politicizing religion. But if she stays silent, no one protects her. On Twitter, the hashtag #crossed the line, both mockery and support, became the #1 trending topic nationwide. A photo of Delaney leaving the hearing, briefcase in hand, face calm and unreadable, was shared over 60,000 times. Nina set her laptop down. Whitmore just accepted an exclusive interview. Local 9, airing tonight. Delaney nodded, unsurprised. He wants to regain control of the narrative. In the name of order? Do you want to respond? Nina asked. Delaney kept her eyes on the screen, where Whitmore was seen stepping into a car, ignoring reporters. I don't need to respond. I just need to keep working and let his own system trip over the very rules it created. Outside, a group of law students from the University of Chicago had gathered, holding signs. Justice needs no uniform, only principles. Delaney stood by the window, watching them in silence. She had never dreamed of being a symbol, but now if she had to be one, she would be the kind people wouldn't forget. Friday night, 7 p.m., Local 9 aired its exclusive interview with a bold headline, Behind the Bench, Judge Gerald Whitmore speaks out. Whitmore appeared in the studio, composed, voice steady, presence commanding. This time he wasn't staying in the shadows. He spoke plainly. Ms. Cross is a talented attorney, but a courtroom is no place to test personal boundaries. If everyone brings their own symbols, we lose the solemnity of justice. The host asked, Sir, she argues that this was a religious symbol that caused no disruption. Why penalize it? Whitmore leaned back slightly, offering a controlled smile. Not because of the earring, but because of how she chose to challenge authority. In court, the judge is the referee. If attorneys refuse to comply, the system collapses. The clip spread quickly. Legal media took sides. Some labeled Delaney arrogant, accusing her of building a personal brand at the system's expense. Others countered that Whitmore was disguising a fear of losing control as maintaining order. At Delaney's office, Nina placed her phone down. 3 potential clients canceled meetings. 1 investor pulled out of the project. Delaney didn't react. She had known this was coming. Economic pressure was always the quietest but deadliest weapon. They don't want to be associated with a controversial lawyer. Delaney closed her laptop. Good. If they believe justice is something to be debated only in silence, they were never the right people to work with me. Nina exhaled, nodding in agreement. That night, Delaney sat alone in her office, with only the desk lamp and the next case file in front of her. She knew this was no longer about an hearing. This was the final test. Who truly controlled the boundaries of the system? Monday morning, 7:45 a.m. Delaney Cross stepped out of the car in front of the Chicago Press Center, dressed not in her usual professional attire, but in a simple white blouse. No jewelry, no makeup, just a black case file in hand. The press conference had been arranged on short notice. The only statement released beforehand read, "Topic, freedom of faith in courtrooms and the limits of judicial authority." She stepped up to the podium, cameras locked onto her. She didn't start with a declaration. She started with a question. If a single hearing can shake a judge's sense of order in the courtroom, then what truly is weak here? Justice or power? The room fell silent. Then she held up the black case file. This is a petition submitted to the Illinois Judicial Committee, accompanied by over 2,300 signatures from attorneys, law students, and citizens demanding a review of the court's dress code and symbol policies. I am not standing here to attack the system. I am standing here to defend the public's trust in it. The press conference was broadcast live, and for the first time, public sentiment began to shift. A constitutional law professor from Yale tweeted, "Delaney Cross isn't weakening the system. She's forcing it to verify itself." At the same time, the Chicago Legal Observer published a survey. 72% of respondents believe personal faith symbols should be allowed in court, so long as they did not disrupt legal proceedings. That evening on the talk show State of Justice, the host said something that made Delaney pause as she was closing a file. If a lawyer cannot bring their beliefs into the courtroom, then perhaps justice is demanding indifference rather than truth. She sat still, not out of pride, but because finally her resistance was no longer a lone voice. Wednesday, 9 a.m., Illinois Judicial Conduct Oversight Committee headquarters, 12th floor, no cameras, no live coverage, but everyone knew the entire state was watching. Delaney Cross walked into the official deliberation chamber. She was no longer the defendant. She had been invited as an expert witness after over 20 legal organizations petitioned for her to defend her argument before the Oversight Committee. Across from her sat 6 committee members, 3 former judges, 1 representative from the state attorney general's office. Whitmore's seat was empty. He had refused to appear. "Ms. Cross," one of the members spoke, "we've reviewed the case files, public feedback, and legal analyses. Now tell us, why is this not just a personal dispute?" Delaney stood. She didn't look at her notes. "Because if I had stayed silent that day, then by tomorrow 10 more attorneys would be forced to remove personal symbols, and no one would question whether that was lawful." She took a slow step forward, voice steady, not angry, just deliberate. If a judge has the unchecked authority to define order without being bound by a universal principle, then today it's an earring. Tomorrow it's hair, skin color, or the law book you carry. A court cannot demand neutrality by erasing what makes people human. No one interrupted. No one even took notes. There was only the silence of agreement. The oldest committee member slowly nodded. "Ms. Cross, I've sat in this chair for 30 years, but today I must admit, we have never truly asked, who keeps the scales of justice in check?" The deliberation ended after 45 minutes, but the verdict was not yet announced. Delaney stepped out of the chamber. She didn't know if she had won or lost, but one thing was certain. She had forced the system to confront itself. 1 month after the final deliberation, the Illinois Judicial Conduct Oversight Committee officially released its findings. There is no basis for disciplinary action against attorney Delaney Cross, and more importantly, the committee recommends a review of courtroom policies on personal symbols to ensure fairness and protect individual freedoms. No grand victory speech, no statues erected in anyone's honor. But in the legal world, this was a shift, subtle yet profound. Delaney received an email from a female attorney in Mississippi. Today, I wore my Star of David necklace in court again. No one said a word, but I know the reason I could do that is because of you. Not long after, Harvard Law Review invited her to write an article. The Quiet Lines We Cross, Faith, Power, and the Law. In it, she wrote, I never wanted to be a symbol, but if the system remains silent every time human rights are eroded, then resistance is no longer a choice, it is a duty. Judge Whitmore was never formally disciplined, but he was not reappointed for another term. Not because of scandal, but because he had lost public trust. For Delaney, the case did not end with victory or defeat. It ended with a new principle. Justice is not just in the verdict, it is in the courage to stand when no one else will. Freedom does not exist naturally within a system. It requires those willing to take personal risks to protect collective values. Delaney Cross did not break the law. She forced the law to ask itself, what exactly are we protecting when we say we are protecting the law? And that, more than anything, is the true role of a lawyer.